Okay.
Okay, so we're going to get started. Welcome, everyone. Thank you so much for taking some time on a July morning here to join us talking about contractor management. My name is Jacqueline Oduro. I'm the Director of Work Safely, and I'm excited to introduce to you Erin Black. Erin is our new Program Development Leader that just joined the team about a month ago. I'll let her introduce herself.
Yes. Hello, everybody. I'm Erin Black. I've been in safety for about 18 years or so, predominantly worked in various consulting role capacities. But the last 5 years prior to coming here, I was the health and safety manager at the Kitchen Craft Master Brand facility here in Winnipeg. And then when the opportunity came up to work with Manitoba Heavy Construction Association and the Work Safely Group, I was very interested in this opportunity, so I decided to make the transition. So I'm looking forward to connecting with all of our clients and meeting with all the businesses and getting to know more about the heavy civil construction sector. So, yes,
Okay.
that's it.
Thanks, Erin. Yeah, you're going to see lots of Erin, so we're so excited to have her. So we have everybody muted to start with, but we would really like this to be an interactive webinar. If anyone has any questions, please jump in, ask your question. Also, if you have any experience that you want to share, there's always really good opportunities to learn from one another if we share our own experiences. And, Erin and I are not lawyers. We have a good general knowledge base for contractor management through our years of experience. But you as well have your own experiences. So we'd love to hear from you. And so we're just going to jump into it. We thought this webinar was a good idea because with the new audit tool, there has been some questions and potentially some confusion in some areas because our audit tool used to concentrate primarily on like subcontractor, prime contractor relationships. And then we have this other piece now on kind of procurement and when a one-off contractor comes into your business, how do we manage the safety for those situations? So we wanted to kind of talk about all of it today and maybe answer some of your questions, what you're seeing, if there's things that don't make sense. But yeah, so that's kind of what prompted this webinar. So we're going to get into kind of the definitions to start with here. So our learning objectives, we're going to start with legal definitions, trying to understand the roles of a prime, a sub, a contractor under workplace health and safety legislation here in Manitoba. We want to look at the responsibilities, what are your key obligations when hiring contractors and managing multi-employer sites. And then we're going to look at some case studies and we're going to look at some prosecutions that have happened recently in Canada and how kind of those played out. And if you guys do follow any of the legal ramifications that occur here in Canada, there is some gray area. And kind of every time there's a prosecution, you kind of pay attention to what is new and, what those indicators are, because that's kind of way it's going to be trending in the future. So we're going to just start with the legal definitions from Manitoba Workplace Health and Safety Act. So you'll notice that in our act, the word subcontractor is not used. Contractor is the main term used for basically both. So it really just means a person pursuant to one or more contracts that directs the activities or one or more employers or self-employed persons involved in work at a workplace. So super general kind of term that's used throughout legislation, but it's basically someone who's been hired to do work and directs the work and activities of someone else. And they could be a self-employed person as well. So very straightforward there. It's just kind of how it's used later is how it gets a little bit more confusing. Prime contractor, and this is always really important, and I'm always so surprised at, it's not usually common knowledge, I would say, where folks kind of understand what a prime contractor is. So it has to be a prime contractor for a construction project if more than one employer or self-employed person is involved at work at the project site at the same time. So as soon as you have two contractors there at the same time, there is a designated prime contractor. And so further down, 7.2, a prime contractor for a construction project. So the prime contractor for the construction project is the person who enters into a contract. So you've contracted the prime contractor responsibilities with the owner of the construction project. But if there is no contract, and a lot of times there is no contract, unfortunately, it's going to default to the owner of the construction project site. So this is one of the only times in safety legislation and like that you can actually contract your responsibilities. And if any of you on the call today understand how much work it is to be a prime contractor and manage the safety of all the contractors on your site, and they're not even your employees, it's massive. And so if you take on a project and you're going to have a contractor, you're going to have more than one sub or contractor on the project, you do want to have a contract in place because it does limit your liability significantly. And it also just clarifies roles and responsibilities. So it's just a really important piece. And especially for smaller projects, there's times throughout kind of history here where there wasn't a designated prime or general contractor assigned to the project or contracted. And so it will default if, again, and it's always, safety, it's always defaulted to the what if. If there's an accident, if something goes wrong, then this is when it really matters, right? If nothing goes wrong, yeah, no one really cares. The project happens and then it closes and it's over with. But if something were to go wrong, how the legal system views it is that it's going to be the owner of the project, basically the person who pays the bills. So you follow that money trail, and that is who they will deem the prime contractor with or without a contract in place. And one of the examples, it's been a long time now, but there was a situation in British Columbia back in the day where Gordon Campbell, I think he was the premier at the time out in BC, he had hired, as a homeowner, he had hired contractors to do renovation at his home. And I think it was roof work. And there was an accident. And he was deemed the prime because he had two contractors at the project and him as a homeowner. Now, we haven't seen that kind of play out. Usually, when it was probably like more political and there was probably some examples made of the guy because he was in a position of power politically in the province. But it could happen, right? It could happen here. And so you do want to, not to scare all those people who are at home doing renovations. We haven't seen that happen here in Manitoba or anything like that. But it's just a small example of even a small project. When the bad thing happens, they're going to look to blame the person in charge, essentially. So then the below the number 3 there is a construction project. So that is important too, is like, what is construction deemed as, right? So it is anything constructing, demolition, repair, alteration, removal of a structure, building, complex, street, road, highway, pipeline, sewage system, like it's all there. Landscaping falls into this category as construction, as we know. So that is kind of like, those are all the primary definitions we need to refer to today, is when there's a prime, and then what is a contractor, and then what is deemed a construction project. Any questions right now? No? Okay, one of the other tips I wanted to say is that when you are drafting your contracts, if you do have a project, is that you should look to build safety requirements into the contract or the scope of work, because that makes them enforceable. So it's not just kind of discussed during orientation or like through emails. Um, Embed safety into your contracts. It makes it a legal obligation and not just a guideline. So you could include specific safety expectations into your contract, like PPE requirements on the site, reporting requirements. If safety meeting attendance is something that you want, you can embed all of that right into the contract, and then that just strengthens the requirements of your contract again to protect you from a safety perspective. Sometimes, you know, I see contracts where you require contractors to designate a safety lead or responsible person for the project, um, and even just non-compliance. You can put that into the contract as well, even with small or reoccurring subcontractors. So this next slide here is just simple definitions of the contractor, just kind of what we went over, but just kind of in layman's terms, right? So the prime is the person with the entity, the company with overall responsibility for safety and coordination at multi-employer work sites. As soon as there was more than one, there's going to be a prime. Then with contractor, that is the entity that's been hired to perform the work and may employ people or may not employ people. And then the sub is the entity hired by the contractor to perform specialized portions of the work. So responsibilities when hiring a contractor. So this piece is the new piece in the audit. This is, and again, really difficult. Like I've been in different industries and it lands differently for different industries. And with heavy construction, we're so used to the prime and contractor relationship. Now this is scaling it back. This is when you at your business where you're employed, you hire a contractor, one company, one person to perform very specific work. So you still need, so it could be a supply person for your business. It could be someone, that you hired to supply you aggregate. It could be a HVAC person. It could be you're getting some electrical work done for your business. And so that's really the big differentiator. We're not talking about a contract or like a big project in this situation. We're talking about when you hire one contractor to do work. So there's still, some safety responsibility there. And again, like everything, it's my philosophy, it's Erin's philosophy, like look at risk when you're looking at this piece and building this portion into your safety program. When you generate a list, I would say, what are all the contractors that we regularly do business with? And do a bit of a risk assessment. What kind of work are they doing? If they're doing electrical, if they're going to be working at heights, if they're going to be going into confined spaces, if they, if they're working on moving pieces of equipment, right? Like some of your delivery for you who have large yards and there's a lot of traffic, that might be something that warrants this portion. But that's kind of when you take a look and go, okay, who are the important contractors? Not important, higher risk contractors that we should be assessing and evaluating. Because again, if someone gets hurt, if they expose your workplace, if they expose your workers while they're doing work, then that's again when that's when you want to make sure you have due diligence, and that's where more measures have to be in place to protect your own workers that are working alongside them in some cases. So the requirements are number one, evaluate those contractors. You would want to put some kind of criteria in place. You probably have been on the receiving. A lot of companies on the line today have probably been on the receiving end of this, where you're being sent an evaluation. So, do you have a safety program in place? Are you course certified? Are you safe work certified? Some of those are easy qualifiers because it means that you've met a standard. Do you have WCB insurance? Is there third-party liability insurance? Those are all very common questions on your criteria, and that just limits your liability. Like this portion of it is really a liability question, and to kind of see, is the company that you're hiring, do they have any safety in place? Because if they don't, you can still hire them, but you have to then provide more guidance and safety, not necessarily training, but maybe safe work procedures, because now you're hiring them knowing that they don't have anything in place. So, and then I would even put on your evaluation selection criteria, do they do any of the high risk work? And then find that out too. And if they do, maybe you want to ask for a little bit more, like, okay, I'd like to see your training. If it's electrical work they're doing, do they have a, one-to-one apprentice if they're doing live electrical? Do they have, any safe work procedures that would go along to cover the work that they're doing? So again, it could be very minimal depending on the type of contractor you're hiring, and it could be more extensive, again, if they're doing more risky work. The next piece to this is you provide them an on-site orientation, and you could require them to conduct a hazard assessment and provide you a copy as well. Again, orientation, I'd say you do for all of them. Give them a base, like who's who in the zoo. Here you are. This is our work site. These are the rules you have to follow. This is who you report to. Please don't use our tools and equipment without letting us know. This is the PP that's required in our shop. Like, you're probably doing it anyway. This is just like you would want to have a form to just document that you've done it and just capture that quick 5-minute conversation. And the question I always get is, well, do we have to do it every time? Again, it's going to depend on the risk. It's going to depend on the contractors. Have you had issues with them before? Do you know them? Have they been working with you for 10 years? Like, you have to use your discretion with this. We don't want to bog you down with more and more paperwork. So use your discretion, determine, the situations where more is required and when less is, suitable. And then the hazard assessment, again, for the high-risk contractors that are coming to do work, I would ask them to, do a quick hazard assessment. It's a new work area. They should be doing it anyway, especially if you're hiring like a core company or a company that's following a different safety standard. So this should be kind of normal to them. And then the monitoring, right? Just periodically, you're not babysitting. You've hired a company because they're the experts in the work that they do. But let it be known to your staff and be like, hey, if you guys ever see a contractor that's not working safe, please report it to so-and-so. And then if you ever see them working unsafe, you have a method to document and kind of follow them up. We even do it here at MHCA. We have people who come up with ladders and they're working on the top rung, and you're like, well, you don't have a proper ladder. Can you go back to your shop and get a proper ladder? Because, we have to walk the talk and we don't want someone to get hurt here on our property. So, so yeah, I would just say, like, in terms of monitoring, treat it like your quality control, continuously verify, not just, pre-qualify your contractors. And as we know, some companies look really good on paper, but perform poorly on site. And this goes along, like, even beyond this, right? As on a construction site or even at your work. So monitoring is really how contractors actually work. And that prevention piece is really in the monitoring. So any questions there? Does that kind of clarify this piece of it? Like, this is really when you're hiring a contractor for your business, separate of a project. By group. Okay, I'll move on. So now just going back, and a lot of this is refresher to many of you, but this is a prime contractor requirements. A prime contractor has a responsibility for safety over the entire project, right? So strict safety oversight. And it is, I think, the hardest thing that you guys would have to deal with is, like, how do you properly control safety and manage, your sites from a safety perspective when, they're often working and doing work that you don't perform personally. That's why you hired them. And then they're not your staff. So, this is this is just a huge undertaking, right? And there's a lot of prime contractors who do this really well, um, but it's a lot. And so, as you guys know, it is, about regulatory compliance, but it's about making sure your projects go smoothly, that there's less loss overall, right? You have less equipment damage, environmental damage, people getting hurt. Like you're preventing all of it, right? Any lost time, downtime. So it's such a critical component of project management overall. So, we have a list here of all the due diligence pieces that you're all probably familiar with, but prime contractors have to, ensure that the toolbox talks are happening, that there is proper training for all the people on the site, that hazard assessments are being conducted daily, that near misses and incidents are being reported internally for each company and then to you as the prime. They have to consider fit for duty. And so, the list is extensive and goes beyond this 12 that we have here. And my tip for this one would be, don't just collect all the policies and the certificates at the beginning of the project site. It's really about what you do with them throughout the project, right? So in investigations, or if you ever find yourself in a situation of litigation, it's not just enough to show that you have the paperwork. You need to show how it was used to make decisions on the project site. So, we're evaluating risk, identifying gaps, following up, monitoring, doing those safety walkarounds. So, keep records of the contractor evaluations for sure, but keep records of the evaluations decisions. Anytime you flagged something for safety, how it was followed up on and discussed. For audit scores, for walkarounds, follow-ups for incidents, that kind of thing. And even, record any contractor meetings or orientations to just show the proactivity on the site overall. Any questions? No? Okay, so this one's pretty straightforward. Subcontractor responsibilities. If you have been hired as a subcontractor or contractor, because these terms are used interchangeably, you have to, communicate your presence, inform the prime of your arrival and any workers that you've hired or any companies that you've subcontracted out to. To follow site safety rules and make sure that everyone in your company knows what those site safety rules, procedures, and protocols are. And then you have to enforce internally yourself. You can't rely on the prime to always enforce. You have to enforce yourselves with your own workers. Train and supervise, right? Making sure that the workers have the proper training for the duties that they're taking on, of course, and then that there's adequate supervision on the site, and then cooperate with the prime and other contractors just to maintain like the safety on the site. And one of the things, I know it goes without saying, but there's lots of cases where companies, a worker, for a specific company, they don't want to say something if it's another subcontractor that they see. And so you see a worker working adjacent to you, it's a totally different company. You know what they're doing is unsafe. I've been on that side of things where something wasn't said, and then that worker gets severely hurt. And having to live with that, knowing that you saw it and could have said something, it's a tough one to swallow. And if that just becomes more of the culture on a site, and if more companies felt comfortable saying things, with kindness and care, there's opportunity to prevent, whether it's within your company or not.
And I also find if something actually is said, that other contractor is typically very like thankful for bringing it up to their attention. Everybody's got eyes on the site. We're all looking out for one another. So, yes.
Exactly. And then multi-employer work sites, like all of you are in the business that you know that there's multi-employer work sites. But it really just doesn't change responsibility. You've got the prime who coordinates overall site safety and communication, and then employer 1, 2, 3, 4, 5. They have to maintain responsibility for their workers' safety the same way, follow site protocols while protecting their workers, and retain your own legal duties despite the prime contractor's role. One of the tips for this is that sometimes you get into multi-employer work sites and large construction projects, and you see that there's overlapping work. And so, if you're the prime or you have questions as a sub, the best thing to try to do is try to, maintain and understand whose role is what. So if you share, you know, spaces or tasks with another contractor, assume some level of responsibility, even if it's their work. And and why this matters is because courts and investigators increasingly look at shared work sites and overlapping hazards, and they consider that. And so if you control the site or schedule, you have shared duties and responsibilities. So you could do pre-job meeting coordination to identify any overlapping work and shared responsibilities. You could look to confirm who controls what hazards, whether it's equipment or traffic, site access, confirm that and then document it. And don't assume contractors are managing their work safely just because they're, independent contractors, right? You have to always be looking out for one another.
Okay, we're going to move on to some case studies and prosecutions that have occurred in the last few years. So we're going to review these 3 case studies: R versus the Greater Sudbury, Joy Global, NCSG and Sungor, and IHawk and Utopia construction cases. So in this first case, R versus the Greater Sudbury, this case began with a tragic accident back in 2015, and now it's 2025, and this court case is still ongoing. It involved into a landmark legal battle. The city of Greater Sudbury hired a contractor for road work. A pedestrian was killed by a reversing road grader. The city argued it wasn't the constructor or employer under Ontario's OSHA. However, courts ultimately ruled that simply contracting work made the city an employer, even without direct control. The Supreme Court's split decision upheld this view, emphasizing that due diligence, not control, would determine liability. So back in 2021, they did have a trial court where the city was acquitted and not an employer or a constructor. In 2023, they went through the Court of Appeal, and the city was ruled an employer due to contracted workers.
And I think, if I remember correctly, it was because the city had sent inspectors there
to check
the site. So they kind of indicated with an inspector on the site, the courts ruled that, hey, you were assuming a level of responsibility.
And then in 2024, Supreme Court split decision upheld the employer status. And then in 2025, the due diligence defense was accepted. So this has been quite an up and down for them, all kinds of appeals, a very costly battle. But so this is very important to be evaluating our contractors and understanding and having clear liability. So when we get to the implications, the owner liability, owners can be liable even without day-to-day control of the operations. Delegation of work doesn't eliminate the legal responsibility. So this case reshapes how we think about liability. Owners can no longer assume that hiring a competent contractor shields you from safety obligations. Courts now expect owners to demonstrate due diligence through contractor vetting, safety oversight, and documentation. For contractors, this means more scrutiny and higher expectations from owners. Everyone on a multi-employer site must understand their role in maintaining safety. So having those clear contracts in place at the start helps to clarify these roles. So due diligent requirements, so thorough contractor selection process, comprehensive safety documentation, regular monitoring system, and clear communication process protocols as well. Is there any questions about this case? No?
No.
Okay, next one we're going to review is a Fort McMurray fatality. So there was a tragic incident, July 7th, 2022, near Fort McMurray, and it highlights the real world consequences of poor contractor management. So 3 companies were fined over $1.2 million after a worker was killed by falling equipment. Each company had a role, whether failing to reassess hazards, not guarding the rigging points, or not ensuring safe practices. The case underscores that when multiple contractors are involved, shared responsibility must be clearly defined and actively managed. It's not enough to assume someone else is handling safety. Every party must verify, document, and enforce safe practices.
I think we have people joining. See that?
Don't know. Let me see. Sorry, we are hearing pop-ups of people. I can't.
Okay.
Okay, sorry.
Keep going.
We just had a few dings notifying us that people might have been trying to just join the webinar. Yes, but this is recorded, so if you were one of those people, sorry we couldn't add you in, and the recording will be on the website shortly. Okay, so the fatality. The worker was struck by equipment falling from a crane in July of 2022. The 3 companies, Joy Global, NCSG Crane, and Suncor, all faced penalties. So root issues were inadequate hazard assessments, failure to guard sharp edges on hoisted loads, and lack of contractor coordination and oversight.
Yeah, that's what you often see too, is in, these incidents that happen, the regulators at the beginning, they'll just kind of throw charges at everybody and then see what sticks later down, how it rolls out with the court. Like we see that time and time again. I'm really interested to see what happens in the case at the Fort Gibraltar, because I think that'll be a situation. And so, for those of you who aren't familiar, the statute of limitations is 2 years. So after an incident, they have 2 years to lay charges. And so I think we're probably coming up close to that. And so I'm interested if it'll be the city, if it'll be Festival.
Right.
I don't even know if there's one more party
I'm
in
not sure.
play, but sometimes there is, right? Sometimes there's like even unions that get involved and stuff. So anyway, that'll be really interesting to see how it plays out.
Actually, this next case talks about employer and also supervisors that were originally charged as well. So IHOC and Utopia construction case. So this occurred back in January 2nd, 2023. Workers used an unsecured portable ladder near an uncovered floor opening. The ladder slipped and fell through the opening, and the worker sustained life-altering injuries. So this incident is a powerful reminder of the importance of contractor oversight. A worker was seriously injured. Both the employer and the prime contractor were fined $168,000 each for failing to ensure safety items were in place. But interestingly, Originally, the employer and the employer is IHOC, and the supervisor were personally charged. The Crown withdrew the 13 charges against the person listed as the employer and the 2 charges against the person listed as the site supervisor. This highlights how complex liability can be for multi-employer sites, and it highlights the personal responsibility that people have as well. Even if charges are dropped, the presence of multiple parties with overlapping responsibility means everyone must be proactive in managing safety. It's not just about avoiding fines, it's about preventing life-altering injuries. So again, this occurred January of 2023. 2 companies, IHOC Construction, the employer who had those personal fines, and the site supervisor as well, and Utopia Construction were the 2 companies, IHOC and Utopia, were the ones that had the original who ended up being charged. Workers sustained that life-altering injury, and each company were fined the $168,000. So the root cause being the lack of hazard controls and contractor oversight. So compliance check. So we just want to summarize some things, safety excellence, maintain consistent oversight and documentation. Want to make sure that we're coordinating those prime contractor safety efforts and maintaining those records. Monitoring regular evaluations of contractor performance that are documented, making sure, when you're walking the site, you're documenting the good or the bad as well that you see. And orientation, documented training for all the contractors, and selection, a thorough contractor vetting process so that when you have used a contractor on a site, and if there was a problem, that you also document that there was a problem. So it's taken into consideration the next time that you might potentially hire them. And you could still hire them, but then you also know that there's a risk there, that they have holes in their system or gap, that you want to maybe put more resources in place to support and monitor them. So some final thoughts. We all have shared responsibility. Safety requires participation from the owners, the primes, the contractors, the subcontractors. We need active coordination. Regular communication prevents gaps in safety coverage. So those meetings under making sure you have clear understanding of who's got responsibility for what aspects. Worker protection, the ultimate goal is preventing worker injuries and saving lives. And legal compliance, stay informed about evolving regulation and case law. Having strong contracts in place as well, it helps to establish those clear legal compliance.
Yeah, and just we have to shift our minds that it's not about the core audit. It's not about a compliance checklist or checking the boxes, but it's to be more proactive from a risk management perspective, so that we're not only meeting our legal obligations, but building a culture of shared accountability. And really, when it comes to projects and large construction sites, prime contractors and contractors, it's very much a shared responsibility environment. That's it from us. Do we have anyone that wants to share some thoughts or have any questions? Any personal experience? Anything goes. Just jump in, unmute yourself and jump in. Oh, we've got some.
Oh, no, that's the
Oh,
transcript.
that's the transcript. Thought maybe it's some questions. Oh, there's a chat there. Check.
Oh, look at that.
Sorry, we couldn't see that.
Oh,
Oh.
Joining back in. Sorry.
So everyone's good on this tough topic. We don't have any questions or anything. It's great. Well, we're going to talk about another webinar we have coming up in July.
On July 10th.
July 10th. So we're going to be talking about the new legislation that just passed. So Bill 29, the Workplace Health and Safety Act, passed and is in effect currently. I think as of June, I don't remember what, but it was like a week or so ago. Yeah. So we'll be talking through, we have Workplace Health and Safety branch coming to discuss Bill 29, exactly, what's changed, and answer any of your questions that you have. And then we're going to be talking about the new regulations for the Highway Traffic Act on towing and snow removal. And then also, I can't remember the bill, but there's one about motor carriers as well. And so we're going to be discussing that on July 10th. So we hope if you're available, you can join, but we do record the webinars. So if you can't join, then watch for it and check our website out.
Okay. Thank you, everyone.
We're done. Unless anyone has any questions, we're going to hang around if anyone wants to jump in or is shy wants to chat. Thanks, Dwayne. All right. Wow, no one jumped in. Usually there's questions.
Okay.
Leave the meeting.
Well, the recording.
We can go back into it later.
Stop recording.
Oh, you'll have